There you go, guys. I'm going to try and do this in one cut because I hate editing. So if it kind of goes off onto a tangent or something, I apologise. I'm not going to fucking cut this shit up. It's so annoying to edit. But also, I'm crook. So if I'm coughing, sneezing, I'm fucking fairly sick. I don't know what's wrong with me. But anyway, as you know, I went to prison for 1 month for disturbing religious worship. This charge of disturbing religious worship is half that of trespassing. Everyone knows trespassing is one of the lowest summary offences you can get. It has a maximum of 6 months imprisonment. Usually judge a charge by the maximum sentence. That's how I usually do it. So trespassing charge is 6 months maximum. Disturbing religious worship is 3 months maximum. So it's half that. It shows you how non-serious this charge is. Now, I know I talked a little bit about the Muslim case. That's a whole side issue. It's not really related in this sense in what I'm going to be talking about in this video. The Muslim charge was pretty much open and shut, not of guilt, but open and shut investigation. I want to get into the second charge of disturbing religious worship. Now, we all know this charge is very old and obscure, and the police are only using it to be political. No one ever really gets charged with this law. I've got a very good defence, which I didn't use in the Muslim case because I didn't want to reveal my defence for this case, because this case is the gold mine, and I'll get to that in a second. I've had friends, because if you've actually been following my channel, I talked about this case more than the Muslim one for a long time, and there's a reason why. Muslim one, not finished. I abandoned the appeal, served 1 month prison, but it's not finished, that charge. I still can take that up to the high court at some point, which I won't get into in this video. But this charge, disturbing religious worship of an alleged gay sodomite church, quite interesting case. And it's interesting, not the charge itself, that's interesting, which I will reveal in the trial, but I'm not going to get into that. That's interesting in a legal argument I've got. But it's interesting in how the police operated in this case, and this is why this case is so serious, why this case is very nefarious, and hopefully it all comes out in the trial. You know, if the court system is transparent and truth doesn't fear investigation, you should see it all. But up until then, I'll do a video now on July 28. I'm going to court for this charge, so I'll do a little brief introduction to this case and the issues involved in this case. Now, I don't want to waffle on too much. I'll give you the bare bones of what's going on. So, an incident occurred on May 12, 2019, where I allegedly went to a gay hall next to a church where I was invited in. I asked for permission to add to the discussion. I was given permission. It turned into a heated discussion over mirroring sodomites. Then I was assaulted and dragged out of the hall by a bunch of sodomites. I did not fight back because I knew what the police would do. They would definitely try and charge me for assault as well, so I was very careful. And a lot of people say, oh, how can you not punch someone when they do this? Trust me, if you're a political activist or a religious activist, you don't punch anyone, even if you're getting attacked, because they will lay charges on you, trust me. It's not about being a pussy or anything, you're just going to be smart, yeah? I get to the front door. This little Asian fellow from the sodomite church pushed me. I softly pushed him back. Then he swapped hands with his phone and punched me straight in the stomach on video. It's not reasonable force. You're allowed to remove anyone from your premises allegedly with reasonable force. Punching someone who hasn't punched you is not reasonable. But we'll get to that in the trial. That's a whole other argument. So the night of the incident, the alleged victims, these sodomites, chose not to make a police complaint. So police can't do anything. If someone doesn't want to make a police complaint, it's not obvious that any major crime has been committed, they can't follow it up. So they did not want to make a police complaint. They asked me, did you want to make a complaint on the assault? I said, well, if they're not, I'm not. Deal. A man's deal, yeah? A month after, I receive a phone call from an informant. Informant is the cop who leads the investigation. Informant Pollack, Brendan Pollack, contacted me for a police interview. I did a police interview where I said no comment, which I advise everyone to do. You never say anything in a police interview because you're not going to talk your way out of getting a charge. That's what I've learned over the years. But I did make a brief statement at the end of the police interview about police political activism, police using their positions of authority to attack people based on their politics, not on a crime. I went into that briefly at the end of the interview. So for a month after, it was about a month after, so from May 12 to when I was interviewed, a few days before that, the investigation started. So obviously someone's made a police complaint. Now, what happened before that, that's the interesting part. See, when if you're not a criminal, you won't know this, yeah? When you're charged with a crime, you receive a brief of evidence. It's basically the prosecution story with evidence of what occurred. It's a big folder. It has all the statements from the witnesses. It has the evidence, and it has a story of what happened and what the prosecutors or informant allege happened. So I received that. I've received them before, pretty much open and shut. So this informant, Brendan Pollack, started his investigation on June 3rd, which is almost a month after the incident. The incident happened on May 12th. So he started his investigation on June 3rd and proceeded to do a timeline in the brief of his investigation. He interviewed the two responding police officers that night, which was David Irvine and Jim Stamatakis. They were the attending officers at the scene that night. So they have their statements in the brief, which just outlined their activities that night. The alleged victims, didn't want to make a complaint. We filed it into the incident report, and that was it. That was it. Police, when they conduct statements of facts, they have to put in all the facts. Omitting something is almost akin to lying. So if you make a statement and you leave things out that are important, that's lying. And I think under the law, that's considered lying, omission of facts. So they, in their statements, just said that, they went that night to the scene and that was it. All ended that night. And then Pollack started the investigation on June 3rd. Now, I'll do a little bit of a timeline how I discovered the corruption of Victoria Police, how it all occurred, because it's probably easier for people to understand. So I got the brief, read through their statements, and one of the attending officers said that he organised for an LGBTI liaison officer to meet with the witnesses. That was it. And that's what led to this whole saga of this case. Okay, that was the straw that broke the camel's back, because that gave me an opening to find out, well, what's this? What's an LGBTI liaison officer? I researched it. It's apparently a Victorian police officer whose whole job is to talk to gay people, okay? To favour gay people, sodomites, which actually goes against their oath and affirmation. They take an oath where they can't show favour or ill will or malice to anyone when they're conducting themselves as a police officer. By their position as an LGBTI liaison officer, they are automatically showing favour to a small percentage of the population. It's against their oath. But anyway, that's a whole other argument. So I asked the informant, anything written in a brief I can ask for more information on. If something's mentioned in someone's statement, I have a right to it. The other thing is, which is important for people to understand, is when police, because if you're not a criminal, it's hard to understand this. If police have conducted an investigation, they have to give they have their case in their brief to prove the case, but they also have a mountain of other evidence that they've collected that they haven't put in the brief, and usually it's either irrelevant or it is doesn't help their case. Okay, but the defence has every right to that information. It's called disclosure. And under common law, the police have to offer up, and the prosecutor, disclosure to the defendant without being asked for it. So in an example of this, in an extreme example, if there was a murder and they interview a witness and the witness says, Joe Blow killed that dude, they'll get his statement and write it down. But then if they happen to see another witness that night and he said, no, it wasn't Joe Blow, it was Kenny. Kenny killed him. They can write that in a note and put it in their pocket. Technically, they have to put in the brief, but they don't have to, as in if they can hide it. But they have to give that to the defence so they can prove innocence or have some form of defence. You have to be able to see all the facts of a case. So saying that, I asked for this LGBTI liaison officer's statement. Now, this LGBTI liaison officer from Burundura Police Station, because this incident happened in Burundura, and all the police involved were from Burundura, because that's how it works, she contacted the witnesses and she gave me a statement. So in her statement, it was quite detailed, a lot different to the responding officers. She detailed when she started, her involvement in the investigation, and at the end. Her job was just reassurance. So she contacted these gay people and asked if they needed any reassurance, etc. What was interesting is at the start of her statement, she said she received an email from an officer Bazinski. Paul Bazinski, I think his name is. Don't even know who he is. And this is just the days after the incident when there was no investigation. Because remember, the investigation started on June 3rd. This all happened prior to an investigation. So an officer Bazinski sent her an email stating far-right extremist, abused gay people, etc. And the email was actually a forward from another officer named Inspector Ashley Mason from Diamond Creek, a whole other police station. Okay, on the other side of Melbourne, he sent an email. Now these emails, they have the CCs and 2, and at least probably 15 to 20 different officers ranking from constable, senior sergeant, detectives, inspectors, assistant commissioners, and even Graham Ashton, police commissioner, and counter-terrorism police. This was sent around, okay, to all these officers. This is before there was an investigation, allegedly investigation. So I find out about this email through the statement. So then I request the email. The informant, Brendan Pollack, provides the email because he has to, because it's mentioned in the statement. The email just outlines Basinski's email, and it cuts out the forward. So the forward I don't have. I don't have access to that. Well, not officially. I'm not allowed to have it. Where they labelled me a far-right extremist, which means terrorist. So here you have a bunch of cops talking to each other, calling the person. They haven't even done an investigation yet. And they've already got a target, which is me. And they've already got victims when there has not been an investigation. And they've got gay cops meeting with the witnesses. After this, I requested all emails from the informant. He gave me a bunch of emails. The main emails I received, which are of most importance, are from, I think he's the boss of the Burundura police station. I think he's the head honcho. His name's Joe Connor. He sent an email saying, talking about he spoke to one of the, and this is before an investigation, spoke to one of the witnesses. This is the disturbing religious worship is the charge we can get Erickson on. That's a quote. I told the witness, I won't mention the witness's name because he's a civilian witness. I told the witness's name what we need to charge Erickson. Okay, this is before anyone's made a complaint. Yeah. Then the week after the incident, about 6 officers attended with the witnesses in the case. Officer Melissa Search, Officer Paul Basinski, Officer Margaret, I forget her last name. Officer Margaret and Joe Connor and Gabby Tayaki, if I didn't mention that, Gabby Tayaki. So they all met with the witnesses a week after the incident at the alleged church. Gabby Tayaki is another LGBTI liaison officer who wore a gay modified Victorian police uniform. She literally went there in the colours of the Sodomites to meet with them. Also who was with them at this meeting is Minister for Sexual and Gender Diversity appointed by Daniel Andrews' Labor government, Ro Allen. They all met with the witnesses and were chatting. This is before an investigation. They're all chatting. There would have been notes taken. I haven't got any access to them notes, apparently. And then that ended. Then in the email from Joe Connor, who proceeded to outline the whole investigation, prior to the investigation, that counter-terrorism, a cop by the name of Mark McCann from counter-terrorism, wanted me charged. He also mentions that they have received 3 detailed witness statements via email from the witnesses prior to their investigation being made. At this point in time, I had no access to these statements. Very important stuff. So then after that, he mentions in the email that the witnesses of the case were meeting to have a counselling session that Ro Allen, the Sexual and Gender Diversity Minister of Victoria, Labor appointed, was organising. So these witnesses had interactions with all the police, interactions with political opponents of mine, considering Ro Allen, who was actually good friends with LGBTI liaison officer Gabby Tayaki. Now, as I mentioned before, the LGBTI liaison officer that was appointed by Burundura Police Station is named McLeod, Sarah McLeod. She was the one who was tasked to go and talk to the witnesses. Who's Gabby Tayaki? Who is she? She wore a gay modified uniform meeting with the witnesses prior to them making statements. She was not allocated the position of reassurance. We were paying her to go meet with these witnesses while there was allegedly no investigation going on. So this is where it gets really sinister. So all that's been said, there's a counselling session, etc. Then I find out that those 2 attending officers, David Irvine and Jim Stamarkis, and it's Joe Connor, Jim Stamarkis, who attended the incident, omitted key facts from their statements. They lied. They omitted that Irvine was the lead investigator prior to Brendan Pollack's brief, prior to his investigation. There was an investigation before the investigation where they collected video evidence. And the other thing is, in Brendan Pollack's brief, when you supply evidence, you have to put down why, who got that evidence and who obtained it, like which officer. He doesn't mention that. He just mentions, I obtained a video. So they collected the video prior to his investigation. Irvine and Stamarkis eventually got the statements in January this year. They were sent to Irvine and Stamarkis via email. Very detailed statements. These statements were very different to the statements that Brendan Pollack, the informant, made over a month and a half later. These are all hidden from me. Now it's turned out, I tried to get this through subpoenas, that Irvine, not only Irvine, but also Stamarkis' notes, police notes, are missing. They've been destroyed. They don't exist, which is very odd. Every police officer has to take notes during their day-to-day. And even if something happened 5-6 years ago, their notes are kept in a filing cabinet. So you're not meant to get rid of your notes. You're meant to have your notes. So from the night of the incident and them emailing the witnesses and them talking to the witnesses, all them notes have disappeared. Not from one, but 2 separate officers. They have the nerve to tell the magistrate that they just don't exist. They were ordered by the magistrate to produce them. Now, this famous counselling session, I won't get too much into it, but this is the counselling session where the witnesses chose to change their minds about pressing charges or making an official police complaint. Daniel Andrews gave this church, this alleged gay church, Metropolitan Community Church, $20,000 or $21,000 in a grant after they changed their minds about pressing charges against me. And I'm not even making it up. They received $21,000 from the Dan Andrews government. For what? We'll find out. We'll find out in the trial. But let's just say that this Ro Allen, this gender and sexual minister for the Dan Andrews government, she is Facebook friends with Gabby Tyaki, the cop who was involved, who the police have refused to even produce a statement or produce her notes or emails concerning her interactions with the witnesses. She's Facebook friends of her, and Ro Allen is Facebook friends with all of the witnesses. Gabby Tyaki's friends with the witnesses. One of the witnesses even states in a public post on Facebook, a civilian witness, that the Victorian police helped them get my video taken down prior to an investigation, even though the video itself was not illegal. Total corruption. So July 28, I'll catch us then. I'm about to sneeze. I'm sick as. Or cough. This is going to be an explosive case. And this is way more important than the Muslim case. Trust me. All right, guys. Love yous all. And have a good day.